Good afternoon, everyone, remotely, wherever you are, and thank you for joining us today for our seminar looking at Professor Samuel's final report on the independent review of the EPBC Act. My name is Catherine Pacey. I'm a partner in the environment and planning team here in Brisbane, and I'm joined by Karen Trainer, who gets the same credentials. On the 28th of January, the federal government released Professor Samuel's final report, which had been provided to the government on the 30th of October last year. The report doesn't say very many nice things about the EPBC Act. It's quite difficult to find some positive statements in there, and it calls for a significant overhaul of the legislation and the processes and administrative arrangements to implement the legislation. Professor Samuel concluded that the EPBC Act is ineffective, not fit to address current or future environmental challenges, and he has recommended that legally enforceable national environmental standards form the centrepiece of reform. So today, Karen has the task of setting out the highlights of the final report and its 38 recommendations, and then I will speak about the national environmental standards and the next steps following the release of the report. So over to you, Karen.
Thanks, Catherine. So the EPBC Act really for environmental legislation has undergone very little change since 1999 when it was first commenced, and Professor Samuel's review is one of the mandated 10-year reviews. It's had one previous substantive review, but not very many things changed. And for most of us, the interaction we have with the EPBC Act is concerning actions or developments that have a significant impact on a matter of national environmental significance, and those matters largely reflect the international agreements to which Australia is a party, and the interaction is sort of on a project-by-project basis. As Catherine foreshadowed, the review suggests a complete overhaul of the legislation and wasn't particularly complimentary in the achievements of the EPBC Act. And I've put on the slide a number of statements out of the report that flag a concern arising from the review that Australia's natural environment and iconic places are under threat. They're increasingly in decline. The community does not trust the operation of the EPBC Act, and the Act's a barrier to that holistic environmental management to look after our matters of national environmental significance. Decisions are focused on individual projects rather than on cumulative impacts and emerging threats. So in terms of the highlights of this complete overhaul that is recommended, some of the core functions are to remain, but there will be a changing way in which impacts are assessed, and there will be improved accountability of decision makers and those who obtain approvals. And so some of the key highlights that we'll talk about today are the legally enforceable national environmental standards and devolution to the states of approvals. To date, the bilaterals have largely been assessment bilaterals, and the report recommends that actually be extended to approvals bilaterals. And Catherine will talk about those national environmental standards in some detail. No substantive changes to matters of national environmental significance, although there's some tinkering recommended. Increased Indigenous involvement in decision making, and the report recommends a reform of the Commonwealth Indigenous Cultural Heritage Protection Laws, which really arises as a result of the fallout from the Junkan Gorge cave destruction And the report says that it's clear that inadequate protection of cultural heritage is inconsistent with the values and expectations of the wider Australian community. A comprehensive and transparent compliance system is recommended, although less tinkering with the rights to review and challenge the decisions under the EPBC Act. And probably one of the fundamental reforms, and I think is very significant if it can be implemented, is to transition from these project-by-project decisions and managed decline of the environment to a restoration focus, and a focus that will allow a holistic assessment of environmental impacts. So just moving through some of those particular recommendations, matters of national environmental significance first. So limited changes are proposed, no new MNES, notwithstanding there were certainly quite significant submissions recommending a climate change trigger. The report does not recommend that. In fact, the report says, that as a matter of policy is intended to be dealt with separately, but rather the EPBC Act should focus on ensuring there is a full emissions profile of development that is being assessed under the Act. That will be the subject of a national standard as to what level of detail is required, but presumably when they are talking about a full emissions profile, stage 3 emissions will need to be considered. And also when projects are being assessed, that there are appropriate assessment of a range of mitigations and adaptation to specified climate change scenarios. So while climate change trigger won't be part of the EPBC Act as recommended by Professor Samuel, the recommendation is to certainly increase the level of information about climate emissions. One of the reforms that there is recommendations concern the water trigger. Now, the water trigger currently relates to large coal mining developments and CSG activities. And Professor Samuel says, well, first of all, it shouldn't be limited to those, but the water trigger, however, should only apply to actions that have a significant impact on cross-border resources, such as the Great Artesian Basin, and within state activities or within territory activities that don't have that cross-border impact, those matters should be the subject of state legislation rather than this Commonwealth legislation. So there will, if the recommendations are implemented, be some changes there. And no real change to the nuclear trigger is recommended. There are significant recommendations around Indigenous involvement, and the report is very critical of the failure of the legislation to do more than give tokenistic consideration to Indigenous views and Indigenous knowledge, and has prioritised those Western knowledge systems. So with the Indigenous Advisory Committee role, the report recommends it be entirely recast, and there be this new Indigenous Engagement Participation Committee, which will have a statutory role to advise on the national environmental standards, including Indigenous participation standard that the report recommends immediately be prepared, that there be a role in providing advice on Commonwealth-led national and regional planning, which is another one of the recommendations arising out of this report, and on listing decisions and other decisions when requested by the Minister. So the intention is to actually create a structure where Indigenous engagement and participation is supported and given a statutory function under the legislation to overcome what has been limited involvement to date in the view of Professor Samuel. Many of the submissions were about the scope of legal challenges to EPBC Act decisions, those project-by-project decisions. Some of those submissions advocate a full merits review of EPBC approval decisions, and others advocate the winding back of the ability to challenge EPBC decisions on the grounds of lawfare. What I think is really important in the report is the acknowledgement that the ability of the public to hold decision-making to account is a fundamental principle of Australian democracy, and that the broad entitlement to bring proceedings to challenge lawfulness of decisions is an important feature of the EPBC Act, given that change to environmental values is a matter of significance to the community at large. So the report fundamentally supports the retention of the existing standing rules, which allow not only people who are directly adversely affected by a decision, but also certain bodies and individuals who have a role in environmental management or environmental protection to have legal standing will remain. So it's very clear from the statements in the report that a legal challenge right will be fundamental to any future iteration of the EPBC Act based on Professor Samuel's findings. Professor Samuel, however, advised against adopting a full merits review as distinct from judicial review that's now available. So currently, if you want to challenge an EPBC Act decision, you need to challenge by way of judicial review on grounds that the decision was unlawful in some way, whereas a full merits review would be an attack on the merits of the decision on the grounds of it's unreasonable or an alternate decision should be preferred. So Professor Samuel said, no, we do not recommend a full merits review, but has suggested a form of review, merits review on the papers, perhaps a bit akin to what currently is available under state legislation to review a decision by way of an internal review. Now, this type of review he recommends should be available to proponents, but also anyone who currently has legal standing to challenge an EPBC decision under the Act. It should be limited to the material that was available at the time of the original decision, so that means no additional information. Limited to matters that have a material impact on environment and heritage outcomes, could apply to the decision and conditions on the decision. Be related to consideration of whether or not the discretion exercise was incorrect or was unreasonable in the circumstances. Now, Professor Samuel also recommends that this merits review should have sort of a gate or a set of criteria that have to be established before the review actually occurs by demonstrating that you have an arguable case or it's a matter of public importance. And the report recommends that one way of doing that would be to have the support of a senior counsel advice that there's reasonable prospects of the review being successful. This raises a couple of issues. First of all, who is the reviewer? This is a decision of the Minister on approval decisions or the Minister's delegate. So who does undertake that review? Does it have to go to the Administrative Appeals Tribunal, or is it to another body, another officer within the department? It's not clear. These are things that will have to be considered if Professor Samuel's recommendation is adopted by the government. Secondly, in terms of this gate or criteria for proving up that you have a basis to review, that will need to be considered pretty carefully if it's a review on the papers. The report's reliance on potential for senior counsel to give advice really changes the role of a senior counsel to an advocate, from an advocate to providing some sort of independent sign-off. So those are matters that will need to be considered quite carefully in implementation of that recommendation. Now, while there are not wholesale changes to the legal review of decisions, there's certainly a focus in the recommendations on a complete overhaul of the compliance and enforcement powers. Professor Samuel's report identifies what I believe he regards as pretty limited enforcement action that has been taken over the many years of the EPBC Act's implementation, with only 41 breaches of the EPBC Act that have been subject to compliance outcomes. And since 2010, so in the last 10 plus years, only 22 infringements have been issued by the regulator, totalling fines less than $230,000. And Professor Samuel says there really needs to be a strong compliance and enforcement stance to build communities' trust back in the EPBC Act and ensuring that the EPBC Act is adhered to. So to do that, it's suggested there needs to be a lot more funding. This funding could be used to invest in appropriate tools and systems for surveillance and risk-based compliance action. There needs to be improvements in the actual tools available to conduct enforcement, such as coercive powers under the Act. The report recommends a review of the penalties under the legislation so that they are proportionate to the significance of the potential impacts, and recommends the creation of a separate Office of Compliance and Enforcement within the department that is focused entirely on EPBC Act enforcement and compliance. There should be a national standard developed for compliance and enforcement to explain the governance arrangements, and states should be accredited with decision-making powers for compliance for those matters for which they will have approved under the state under an accredited arrangement. So if something is approved by the state under a bilateral, then the state should take up the cudgel of enforcement. And to further address what Professor Samuels has identified as community distrust in the Act, it's recommended that an independent Environmental Assurance Commissioner be appointed immediately to oversee the performance of decision makers under the Act, including the states and territories operating under delegated or accredited authority, undertake audits to monitor the effectiveness of the Act and its operation, and investigate any complaints about how the Act is being implemented. So that is a body that would be appointed to ensure the Act does what it set out to do. Now, I mentioned at the start one of the significant reforms is a new focus away from project-by-project decisions and management of environmental impacts to a system that makes some holistic decisions on good data, regional scale information, and encouraging restoration of the environment. And the report recommends that this can be done by better planning. And the recommendation is really driven by concern that cumulative impacts are difficult to assess and not effectively assessed when you're dealing with project-by-project decisions. Project-level decisions in the report are reported to not fully factor in other pressures on the environment, and there's been limited use of strategic assessments which were designed to enable regional scale assessments of a program or plan or undertaking. There's no requirement for a comprehensive set of national and regional plans in the EPBC Act. Certainly there are some planning tools that exist, but not all of those have statutory force. And one of the examples is bioregional plans, which can be developed in a Commonwealth and state area in collaboration with the state or territory. But if it's not wholly within the Commonwealth area, they're not statutory and not required to be monitored and reviewed. The approach to planning for recovery of threatened species and communities was criticised by Professor Samuel as being based on a species-by-species approach rather than a more holistic approach. And the ability to respond to key threats and bushfires, such as bushfires or biosecurity, is cumbersome. And while there is an ability to list key threatening processes, until a threat abatement plan is made or adopted, it's just a listing. So the recommendations really say we've got to get better at planning at a national and regional scale. And so some of the new plans that are recommended are strategic national plans for the big ticket items such as climate adaptation and management of feral animals. And that will improve the capability of dealing with acute threats to matters of national environmental significance such as bushfires, which is really something that has been a challenge post the last year's bushfire season and the impact that it had. Regional recovery plans at a landscape scale, so shifting from only species-by-species recovery plans to regional recovery plans that identify where the important populations are and what are the habitats critical to survival of those species. The use of ESD plans, which again are like a spatial planning instrument, which identify areas to be avoided or impacts to be managed quite carefully, areas where there's a high or low risk of impact, and the types of development that might be allowed in an area or need not take approval requirements. So if we do that, that certainly will require a bit of coordination with states and local governments to avoid inconsistent planning instruments. And he's recommended that the existing tools such as strategic assessments stay as part of that suite of planning instruments, but he's recommended some tweaks to the strategic assessment process to give them more flexibility, because at the moment they're very static documents that can't be amended and need to be more flexible so that they're not set in one particular point in time. So given that new focus for the EPBC Act, what does that really mean? Well, I think it means significant funding to allow for this planning to occur, significant resources to do that. It means that there needs to be that close coordination with states and territories, given that, and also local government, given that a lot of this sort of statutory and spatial planning occurs at that level. So, you know, you don't want, as I said, inconsistent planning, and you want to take advantage of some of the work that's already been done. Collation and reuse of data, because this will only happen if there's good data. And at the moment, data is largely collated in lists of species and project-by-project assessments. So how do we get good data sets? And that's certainly another focus of the National Environmental Standards. So at that point, I think it's a good point to hand over to Catherine.
Thanks, Karen. And I did forget to mention in the introduction that all of your questions for Karen can actually be submitted through our Q&A function. You're welcome. So the National Environmental Standards were raised in the interim report and have been further developed and carried through to the final report. So these national environmental standards, Professor Samuel envisages them as a legally enforceable set of standards which underpin all of the reform processes that he has identified. The report very clearly stresses that the standards evolve over time and that they have to be read as part of the broader reform that has been recommended in the report. And that's very consistent with Professor Samuel's theme through the report, that what the report is a package of reforms and it's not something to be cherry-picked so that selected bits get implemented. Without actually implementing that package, he says we don't move from that point of managed decline to restoration. The standards will need legislative amendment to be supported and implemented, so it's envisaged that they will be regulatory instruments that are legally enforceable. Presumably part of the consequence of that status of the standards is that if the standards are not complied with in decision making under the EPBC Act, that those decisions can be subject to legal challenge. The standards are also intended to apply at all scales of decision making under the EPBC Act and provide some flexibility for development. Now, I think that's actually a real challenge of the standards. So it's intended to apply to everything from your project by project decision all the way through to accreditation of state processes and strategic assessments and the larger scale planning that Karen spoke about. That's actually very challenging for one set of standards to address. And the way the EPBC Act is currently set up, if you care to focus and really wade through 2 volumes of enthralling legislation, is that you have a separate set of standards that apply to accreditation and approvals bilaterals compared to decision-making criteria that applies to project by project. And presumably the rationale for that is that a project by project decision doesn't have the same flexibility that a whole of state process can provide in terms of environmental outcomes. Sorry, yep, got the, the clicker. So Professor Samuels has recommended that a full set of national environmental standards be adopted without delay. And the review has included 4 of those national environmental standards. One is for matters of national environmental significance, and that also includes a subset of standards for each of the matters of national environmental significance. One for Indigenous engagement and participation in decision making, and that theme is also woven through the standards for matters of national environmental significance. One for compliance and enforcement, as Karen discussed, and a real feature of that is the focus on independence and a lack of political interference in decisions about compliance and enforcement, which is an interesting challenge for something that remains part of the political system. And also a standard for data and information. So these standards that were further developed from the interim report, Professor Samuel says there has been further consultation with science, Indigenous, environmental and business stakeholders, and also input from technical experts. Part of the initial suite of standards that Samuel recommends also includes standards for Commonwealth actions, so actions of Commonwealth agencies, and actions involving Commonwealth land, transparent processes and robust decision making, environmental monitoring and evaluation of outcomes, environmental restoration including offsets, and wildlife permits and trade. So there are some challenges with the standards, and the initial set of standards, as I've said, are not intended to solve everything. They're the first step and an interim step in achieving the outcomes that Professor Samuel is seeking to through his recommendations. So we've spoken about the challenges of the standards applying at all scales. Part of the rationale of having the standards is really to enforce that devolution to the states, or the approvals bilaterals, or I think the federal government's catchphrase is the single touch approvals. And the rationale that Samuel applies is that the standards should be significantly specific and prescriptive, that it should not matter who actually makes the decision, so long as they comply with the standards. The standards that Professor Samuel has included in his report do go beyond the requirements of the EPBC Act decision-making criteria, and that it would operate, depending on how the legislation would be implemented, but it could operate to act as a quasi-stretch or extension of the EPBC decision-making criteria. So the standards that are included in the final report include things like cumulative impacts, which is broadly used in assessments and decision-making under the EPBC Act, but is not actually enshrined in the legislation. Environmental offsets, which currently rest in the 2012 Environmental Offsets Policy. Professor Samuel has recommended that that policy be updated and longer-term offsets be enshrined in the legislation, but what he's done in terms of the standards has actually prescribed that where you're looking at offsets, there is a requirement that the offsets be achievable, which means that there must be demonstrated scientific knowledge on how to restore the habitat with a high confidence of success and long-term protection, and also that offsets be ecologically feasible, which is being able to demonstrate that a species or community can be reliably restored, and importantly in a timeframe proportionate to effectively address the impact of the action. Other places where the standards stretch the current decision-making criteria of the EPBC Act is that there is no net reduction in extent or condition of habitat, remembering it applies at both a project-by-project and system-wide level, and that decisions are made based on best available information, which goes back to Karen's point about ensuring there's quality data to underpin decisions made under the Act. So Professor Samuel has acknowledged that the standards that have been included in his report in themselves will not deliver the level of protection required, and there is that need for further and fundamental legislative amendment to support the standards. They are designed to evolve over time, so the standards that are presented in the final report are designed as a starting point. And the vision is that a state or territory could adopt the standards and that be used as the basis for accrediting a state or territory approvals process under a bilateral agreement. So last week, some of the press got hold of what might be called the alternative standards. And this is a set of standards that, according to reporting, has been developed by government in consultation with various groups as an alternative to the standards that have been put forward by Professor Samuel in his report. Now, to my knowledge, and I haven't done it through Facebook, so it might be more reliable, but to my knowledge, only the MNES standards have appeared, so I don't know whether it is intended that there will also be the standards around compliance and Indigenous involvement and data. The standards that have been released have been criticised for not going far enough and for not adopting many of the recommendations of the report. And the standards that have been released, I think it's fair to say, largely replicate the existing EPBC Act provisions, particularly in terms of decision making. That's no small achievement, however, if you've spent quality time with the EPBC Act, because what those standards actually do is draw together the multiple locations proponents and decision makers need to go to in the EPBC Act to work out what the decision making criteria actually is across all 2 glorious volumes of the legislation. Professor Samuel did say in his report, which I'll remind you was not kind to the legislation, that the requirements of the EPBC Act are buried within hundreds, which I think is actually thousands, of pages of legislation, statutory documents and unenforceable guidelines and policies. So while a criticism of the standards is that it doesn't do much beyond what's already in the EPBC Act, I think it is quite an achievement to pull it together. And the EPBC Act provisions in themselves can achieve quite a lot in environmental protection. I think there's a lot in terms of implementation that could be improved in the Act before you get to legislative amendment. One of the advantages in not stretching the decision-making criteria in the EPBC Act is you do avoid that legislative minefield of having instruments that go beyond the powers of the primary piece of legislation and having to deal with potential inconsistency between the enabling legislation and supplementary instruments. So it may actually provide initially, at least until the EPBC Act is amended, if that's what ends up happening, some greater certainty for those standards in how they are actually going to be implemented. The standards, the alternative standards, as we'll call them, I understand have been criticised by some states and territories with a preference expressed for the standards put forward by Professor Samuel. The reason these standards exist is not only an enthusiasm to implement Professor Samuel's report, but you may recall that the Environment Protection and Biodiversity Conservation Amendment Streamlining Environmental Approvals Bill, which is a really easy name to remember, is currently sitting before the Senate, and some of the criticism of that bill that has come out of the Senate is that all it does is deals with the devolution of decision-making processes to the state and did not address the national environmental standards which were recommended in Professor Samuel's interim report. So it's likely that these standards will be used as part of the negotiations for the passage of that legislation, although I think based on the current criticisms coming out of the Senate that some more work will need to be done. Yesterday it was a hot topic in Parliament and the Senate passed a motion that, I quote, government has bungled, and bungled is actually a word used in a Senate motion, the opportunity for reform by ignoring and cherry-picking the recommendations from the report and pursuing second-rate so-called standards. So it would appear from that motion that the Senate thinks there is still some work to be done. So legislative reform is great, it's exciting, it gives Karen and I things to read at night, but it has its challenges, and when we're looking at how the standards can be implemented and the legislative changes required around that, transitional provisions are always a very important part of this process, and for the legislative draftsman it's actually always the most complicated part of drafting legislation. So if you have not a controlled action decisions under the existing legislation, you have existing approvals that you may in the future need to amend or have extensions for, you're partway through an assessment process, or you're relying on existing use exemptions, what happens with these transitional provisions will be very important to you. It will also be an issue for the standards, so how the standards will impact on those existing rights and how changes to the standards, given that they're intended to be interim and evolve over time, how changes to those standards would impact on accreditations of state and territory systems that have been accredited based on the standards will be an interesting one. One question that we have seen appearing from clients in the last little while is whether applications should be lodged now ahead of the reforms. I keep forgetting to bring my crystal ball to work, so it's a difficult one to answer. But the thoughts I give are this: one, if the amendments are made and there is a genuine reform of the legislation, you might end up with a better procedural process to be followed in terms of decision making and applications and certainty around the outcomes of those decisions. On the other hand, I think it's quite clear from Professor Samuel's report and a lot of the other commentary coming out around it that we're not going to see a lessening of standards of environmental assessments or decisions, and you would only expect that the required outcomes of applications will need to be higher. So what now? We've had our second statutory independent review of the EPBC Act in its 20-year history. And as Karen said, despite us having very similar conclusions reached in both reports, different ways of achieving them, we've actually never seen really fundamental changes to the EPBC Act in its 20-year life. Now, in response to some questions in the House of Reps yesterday, Minister Ley, who's the Minister responsible for the EPBC Act, really threw it under a bus by saying nobody loves the EPBC Act, which was a little harsh. So what Professor Samuel has recommended in his report is a three-step reform process. So the first tranche of reform is that there are immediate priority reforms. And those reforms are to give legislative effect to the standards, probably to actually agree them to start with, to introduce an Environmental Assurance Commissioner who will oversee the national environmental standards, to fix the various statutory advisory committees under the EPBC Act and streamline those committees and have more certainty in the role of those committees. To implement modern compliance and enforcement powers with an independent compliance function, to fix the numerous inconsistencies, gaps and conflicts within the EPBC Act, and I think a lot of that's particularly around the strategic assessment process, and also quite critically to review the national level cultural heritage protections. Tranche 2, which is within 12 months, remembering that Professor Samuel wrote his report in October of last year, is that there will be significant planning for the reforms required for environmental restoration, improved data and information, that the initial set of national environmental standards will go through a review to see what changes are required based on their early implementation. The whole of parts 3 to 10 of the EPBC Act be overhauled to integrate the national environmental standards. Now, parts 3 to 10 of the EPBC Act are the parts that most of us work with regularly. So they're the parts around environmental approvals, bilateral agreements, both assessment and approvals bilaterals, and strategic assessments. So just that little overhaul. That the provisions around the Commonwealth giving advice, which apply in relation to things like development on airports, be removed. So all of those types of Commonwealth agency functions actually be brought within the remit of the EPBC Act instead of having that advisory function. And that the limited merits review that Karen discussed be implemented. And then tranche 3 is really where you pull out the sledgehammer and just completely reform the EPBC Act. So this is a reform of the major functions of the EPBC Act. Professor Samuel is suggesting consideration of whether the Act should actually be broken up into numerous pieces of legislation instead of one. And also implementing long-term strategies to leverage private investment in restoration, which seems to be recognising that government can't and probably shouldn't be responsible for moving us from a decline to a restoration remit. So government has not yet given a formal response to the Samuel review. We have had a couple of media statements and the transcripts of Parliament yesterday, but it appears that what government is immediately committed to is what they're calling the single touch approvals, so the approvals bilaterals, underpinned by the National Environmental Standards. Government has said that the standards will initially be interim and will be moved to a final set of standards within 2 years. Each Premier and Chief Minister, according to Minister Lay, has committed to streamlined single touch approvals at the December 2020 National Cabinet meeting. I think they actually did that in 2013 as well, so hopefully it moves a little bit faster this time. And also as a high priority is modernising the protection of Indigenous cultural heritage. So as I mentioned earlier, the Streamlining Environmental Approvals Bill is currently sitting before the Senate. We expect negotiations on that to continue, and hopefully we'll have some movement on it so we don't have another 20 years with no significant changes to the legislation. Now, Professor Samuel's report is not a light read, and what government has said is that they are working through the other recommendations, and they will with time produce a more fulsome response to the report and actually work out how some of the recommendations will be implemented. So that's all we had, but we have some questions. So one is a feel for the timing of implementation of the changes. I think it's safe to say we probably won't meet Professor Samuel's program, given a lot of work has to be done this year, and from what I understand, we're heading into an election year, so it will probably be challenging to meet the program that he has suggested, and we don't yet know whether government even accepts all of the changes and will press ahead with them. So hopefully it's something that actually results in some changes, both for economic development and for the environment, so we can see some real meaningful change coming out of the EPBC Act. Second question we have is, do you think more project refusals are likely if Samuel's recommended standards are implemented? I think they are, and you'll have harder conditions. They're setting a higher standard than what we currently have in the EPBC Act. The recommendation from Samuel is that there be no discretion in terms of compliance with the standards, so decisions have to be consistent with the standards. The only exception he makes to that is for decisions by the Minister where, as a matter of public interest, there should be an ability for the Minister to deviate from the standards, but that should only be done where a statement of reasons is published and there is full transparency about the reasons for the departure from the standards. That should be contrasted with the current criteria, which at a high level talk about compliance with or making sure there's not a significant impact on matters of national environmental significance, but allows the Minister to consider social and economic factors in making the decision without any weight or more detail being prescribed around those social and economic factors.
Can I add to that?
Please do.
I think the EPBC Act has pushed creativity and innovation in terms of dealing with issues. It's certainly pushed the attitudes towards offsets at the state level. It's pushed creativity in terms of management and identification and management of important areas. And so even though we might see another level of requirements and control as a result of the national standards, I would hope that that will again push innovation and creativity in response, so that projects can proceed where it's appropriate for them to proceed, but with innovative solutions to manage, not only manage impacts, but actually encourage special places to remain special places, and to give them the financial and resource capability to improve and restore. So I think there will be a bit of balancing. There'll be a lot of shifting of goalposts initially, and certainly harder scrutiny, but I think it's a positive thing generally for those criteria to go up another notch. We know more, and as technology develops and information develops, we should be a bit more creative.
Yeah, and I think I've seen over the course of my career the quality of environmental assessments and approvals that you have now compared to many years ago has certainly increased, and I think in large part that's because of the EPBC Act and the requirements that it's imposed. I think it's fair to say also that Professor Samuel has set a large task, and it is a large task, but with very well-resourced and clever broad-scale planning, you can actually achieve that protection of special places and better offset delivery and more certainty around where development can and should occur and what places should be conserved. So it's an opportunity, but there's a lot of work to be done to implement it. So that is the end of the questions we had. So thank you everyone for joining us. I think a copy of the slides and this recording, so you can watch us do this all over again, will be sent to you. But of course, if you have any follow-up questions or anything you want to discuss out of today's seminar, please don't hesitate to contact either one of us, and we'd be delighted to talk to you. So thank you for joining us.
Thank you again.